Just this week, the ACLU of Texas sued Travis County for failing to provide counsel for defendants in jail during their first appearance. KVUE's Malia Masamoto joins us in the studio. And Malia, you spoke to the ACLU about this lawsuit, and they say providing counsel at first appearance is actually something Travis County has never done consistently.
Yeah, that's right, Darnisha. Despite the fact that having counsel before your first court appearance is a constitutional right, Travis and many other counties in Texas have actually never made that a priority. And these are hearings where the magistrate judge can ask them some tough questions about their cases. And without having this counsel, it can cause the defendants to say some things that could jeopardize their case. It won't be long after you get put in jail in Travis County that you'll have to face a judge.
Typically within hours of an arrest, you're brought in front of a judge, and this judge makes a decision about your bond amount. They tell you what your rights are.
But if you aren't fortunate enough to afford an attorney, you won't have any counsel before that first hearing. You will get a court-appointed attorney, but the ACLU of Texas says it's typically days before defendants can even talk to them. And from what they've observed from watching these hearings, the magistrate judge tends to ask some condemning questions of the defendants.
Many people are saying things that could harm their case.
But they say if the defendants had access to their attorneys beforehand, it would look a little bit different.
If you can afford to hire an attorney, you can get on a fast track out of jail because they may be able to go to the magistrate judge outside of these hearings and advocate for your release.
Attorneys can also negotiate bond amounts and conditions with the judge before that hearing. But without counsel, these defendants are just left sitting in jail, which is why the ACLU of Texas decided to sue the county.
It's indefensible, it harms families, and it's wasting money.
In a statement, Travis County said they're going to start implementing counsel at first appearance with 2 trial shifts next week and more in May. They acknowledge the impact of having counsel, saying, quote, "By implementing CAFA, we can help make our communities safer and more resilient by stabilizing families and reducing the amount of time a person spends in jail after an arrest and while awaiting a trial." But the ACLU of Texas says this response is lackluster to what more they believe the county should be doing.
The baby steps we've seen are inadequate, and it leaves the vast majority of people without attorneys at these hearings, which they need, and that's constitutionally required.
Now, the county did try to implement a counsel at first appearance pilot program back in 2022, but shut it down due to staffing concerns. But the ACLU told me, frankly, they don't think staffing shouldn't be an issue when it comes to ensuring people's constitutional rights. So that's why they've gone so far as to file this lawsuit.
Wow. So, Malia, is this impacting other states or just Texas?
Yeah, unfortunately, Texas has been, one of these main ones who's been a little bit slower to recognize this constitutional right. But they're not alone. There's been some other states that have also been not paying attention to this rule, and they've already filed lawsuits in Oklahoma, Oregon, and Utah. So the ACLU has been on it, and it's going to be a thing that's been coming more to light recently.
All right. I know you'll keep us updated on this. Thank you, Malia.